But their discovery that the state's top cop is on the take was and is extraordinary. Criminals have an MO, a modus operandi, a method of operation, just like any common theme of a thief, a rapist, a murderer, where they have patterns that can develop over time. And Paxton has shown over time he has a power in his ability to not respond until caught. Once he has learned he is caught, he will often lean on political friends, delay the process he could to avoid the courtroom, and lie to the public for almost a decade, thinking his reelection served as the ultimate get-out-of-jail-free card. We sit here to judge like any other grand jury to decide whether or not we want to move forward. And criminals rarely confess. That is why we don't have to prove motive, and we don't have to prove cases in any other way than ideas such as circumstantial evidence. And so let me explain circumstantial evidence. We have all been in the grocery store, and I want you to imagine that you turn down the aisle, and as you start down the aisle, you see another person coming the other way. They're pushing their buggy. They've got a child sitting there in the top of it. They're reaching up for items. They're looking down at their list, and as you get to each other, "Oh, I'm so sorry. Are you okay? I didn't mean to hit you." Do you think that they meant to hit us? You can see all the circumstantial evidence around it and say, I don't think they meant to hit us. Now let's take that we turn down the aisle, and on the other end of the aisle there's a cart coming, a person pushing, no distractions, no baby, no list, and they're coming right for us. And we move over the other way, and they come in our lane, and we move over the other way, and boom, I'm sorry, I didn't mean to hit you. Do you believe that? It is the same analysis that we go through in looking at an entire timeline when determining criminal activity. We also are not required, when a potential offender tells us a statement, that we have to take them at their word. We look, and we are responsible for evaluating and looking at all the circumstances. And so let's take a look at what's happening with Texas Attorney General Ken Paxton. It's around October 2020, and the office is beginning to scramble in a crisis. Calls are starting to come in because there are agencies and entities receiving subpoenas that they are wondering, what in the hell are you doing? Are you really looking for this kind of information? At that point, they are aware that there are more than 30 subpoenas that have gone out to banks, asking for loan information, checking and saving account information, personal cell phone data of bankers, investigators, and a judge. They begin to recognize that these subpoenas are supposedly authorized by Brandon Kamek. Who the heck is that? You have these entities of operations of men who have been in different silos who all come together, and they all, at that point, sitting around with each other, realize that there is a common thread that they are hearing, and they all perk up. They realize the conduct that the Attorney General has independently been committing with each of them over a course of a number of months. All roads lead to Nate Paul. All of them recognize through their own independent discussions with the Attorney General, they have warned him, Nate Paul is no good. You can do a common Google search and see his bankruptcies, and there is no way you should have anything to do with him, and there is no way this office can participate in anything on his behalf. Article 1. When Ken Paxton asked the Office of the Attorney General to interfere in the Mitty Foundation, as Representative Spiller has spelled out, he turned the Attorney General's office against a nonprofit. As the lawyers for that nonprofit said, quote, they felt ominous pressure, being forced to attempt to settle on the cheap to the benefit of Nate Paul. When the Office of the Attorney General suggested that they settle for $5 million when they had a $10.5 million already recognition of Nate Paul was supposed to provide, and then later being recognized that the value of that case to them was $21 million. You heard from Representative Spiller that unusually Ken Paxton involved himself in these matters in a way he had never before done with regard to a charitable entity. He broke the fundamental rule that this body has passed to say that the Attorney General will protect nonprofits for the interest of the vulnerability of all Texans. And in this case, he turned that on his head, represented his friend, and he broke the law. This article represents abuse of official capacity, which is a third-degree felony warranting 2 to 10 years in prison. Article 2, when Ken Paxton asked the Office of the Attorney General, as Representative Spiller just displayed, what they called the midnight opinion. Nate Paul has 13 properties that are in foreclosure, and they know that he has one or more set, or he knows that he has one or more set this next Tuesday. They go scrambling, and they originally write an order that says there is no need for us to shut down. Ken Paxton says, no, do it the other way. They acknowledge to him and say, you do get that we're going to say that while it's COVID, that 10 people can't get together outside for foreclosure, and that goes against every other policy that was being issued at the time by the state with regard to COVID. They issue it anyway. When Nate Paul is deposed and he is asked, did you have contact with Attorney General Ken Paxton before that order was done? Quote, yes, I had contact with him before that, end quote. Ken Paxton, he broke the law. This is misuse of official information, another third-degree felony warranting another 2 to 10 years in a prison. Article 5. When Ken Paxton sets up this rare lunch, he asks the Travis County DA's office to sit down and meet with Nate Paul. He makes a personal introduction. As a courtesy, the Travis County DA stays. They listen to Nate Paul and they think there is nothing here for us to do to investigate. He insists that he wants them to try to help him because he believes that he has been falsely accused and needs to get access to information with regard to the FBI. They require that you give a sworn statement. And the reason they want you to give a sworn statement is you want to try to prevent people from using law enforcement agencies for false and vindictive purposes. He doesn't give a sworn statement. Travis County says, nothing for us to do here. There is no there's no case there. Ken Paxton then assigns Mark Penley, Deputy AG, and David Maxwell, the Director of Law Enforcement, to meet with Nate Paul and to meet with him. They again tell Ken Paxton, quote, no evidence of a crime and no state interest, end quote, is here. There is no reason for us to get involved or have anything to do with this guy or his allegation that the federal government has tampered with him. Ken Paxton insists, do it again. At this point, Nate Paul comes back and he has some records that he suggests have been tampered. The Attorney General's office then has an expert go through the point of doing analysis on the document and again comes back and says, there's nothing wrong here. This document has not been tampered with. Ken Paxton says, I just need you guys to meet with Nate Paul and tell him. They again sit down in a room with Nate Paul, Ken Paxton, and these senior officials, and they say, look, there's nothing here that this office can do for you in this circumstance. They describe that Nate Paul gets, quote, incensed, end quote, and, quote, dresses them down, senior staff, like they were his employees, end quote. These two men, for decades, say, we're not getting involved, we're not doing this. As Representative Spiller said, there are some 800 lawyers that can engage in criminal issues. Ken Paxton, Freudian slip, decides that he's not going to let it go. Ken Paxton is going to now look at 2 different individuals to hire to act as a special prosecutor, one of which is decorated, decades of experience in prosecutorial experience, and the other is a 5-year lawyer, defense attorney, and never been a prosecutor. Guess which one gets hired? The guy that's got no prosecutorial experience, and it's because he comes at the recommendation of the attorney who works for Nate Paul. Ken Paxton sets aside money for this young individual to work, and he tells Penley that he needs to hire him. Penley refuses and will not sign the contract. He says no. Ken Paxton again asks on a Saturday, come meet me, I want to talk with you. They meet in McKinney, and when they do, Penley again warns Ken Paxton, quote, you are exposing yourself to potential criminal liability, end quote. He says, do not do this. And Ken Paxton says, you gotta sign the contract. He's been working for 2 weeks. He needs to get paid. Penley then says, fire him. I will not participate and I will not supervise this guy. And Ken Paxton responds, quote, don't worry, I will, end quote. The grand jury subpoenas that are put out include bank records, individuals, and contacts as already recognized with regard to investigators and a judge in a case involved with Nate Paul. This raises serious questions about the release of public information. It raises serious questions about exposing a search warrant. And why do we have search warrants and why do we redact them? Because we appreciate law enforcement. We appreciate those witnesses that will come forward in the interest of justice, and we do not turn over those files to a target, because what can happen? Witnesses can be tampered with and evidence can go missing. It is a fundamental tenet of offices of prosecution and law enforcement that you do not expose those individuals. But as Representative Spiller has already indicated, there is a correlation between the access of that unredacted file and Ken Paxton to Nate Paul, and sure enough, it is those individuals and their information that's being sought in this warrant. One of those investigators later goes to get his car fixed, and when they get the car fixed, you know how they raise it up? He says, hey, can I take a look underneath? And finds a tracker, and finds that that tracker has been active and searching, and it's been on around the time that these things start happening. Ken Paxton broke the law. Misappropriation of fiducial property, which is a state jail felony, carrying 6 months to 2 years, and another case of bribery, carrying a second-degree felony of 2 to 20 years, and abuse of official capacity, another third-degree felony, carrying a punishment range of 2 to 10 years. Article 3 and Article 4, when Ken Paxton asked that they issue this no decision, when you have the receipt of the manila folder that he has for 7 to 10 days, when we know, like any other criminal who wants to cover his tracks, he doesn't hand it to Paul himself. He gets a young aide, gives him the package, and asks him to deliver it to Nate Paul at one of his Austin businesses. Ken Paxton, again, broke the law. Misuse of official information, abuse of official capacity, again, an additional third-degree felony warranting 2 to 10 years in prison. When these whistleblowers, these individuals find out what's happening, they begin desperately to start cleaning up Ken Paxton's mess. They recognize that those 39 grand jury subpoenas that go out, and let me explain how this happens. The Attorney General typically will assist in other counties. So it is not unusual that they went to Travis County and they said, I need to issue these grand jury subpoenas. A grand jury subpoena carries weight. It means you must comply, and if you don't, you're in violation of the law. It was issued by, quote, Special Prosecutor Brandon Kamek, and it was signed by a judge. It is the Attorney General's office themselves these entities, these individuals who started to see when it boiled over and realized what was happening around Nate Paul, that they go file motions to quash. A motion to quash means I'm telling you, you no longer have to respond to this order, and in doing so, they say that the individual that had submitted them did not have the authorization and should not have done it, and they should not comply with that response. Articles 9 and 10. Articles 9 and 10 relate to the issues of the affair and the renovations. Why is the affair important? The affair is important because it goes to Ken Paxton's political strength. He knows that with his folks, he is family values. He is a Christian man, and the idea of the exposure of the affair will risk him with his base. In fact, when the affair comes out, there are a couple of people in the office that say, I can't work for you, and I'm leaving. He has an interest in attempting to keep this affair quiet. He also has an interest in continuing it. Another staff member says that he comes to them distraught of how he is continuing to be in love, and she tells him, what the heck are you doing? You are exposing yourself, and you are exposing this office to potential blackmail and potential influence, and you can't do it. The other benefit is that Nate Paul giving his mistress a job means that he no longer has to drive back and forth from San Antonio to see her, and it makes her more convenient and here in Austin. With the renovations, you may have heard part of the story with the renovations is that they have a home here in Austin that is undergoing floor-to-ceiling renovations. The idea of this is that there is a young man with Ken Paxton. He normally has a security detail, but he starts doing things without that detail, and he starts doing things that are not on his schedule. One of those things is going to this renovation house, of which there is a disturbing encounter. This young man realizes that as they are standing there in the home, and Ken Paxton says, hey, we want to change out these countertops and get something else. And they say, it's going to be like $20,000. That's all right, go for it. The contractor says, I'll have to talk to Nate. This young man is disturbed by it. In fact, he's crushed by it. He believes Ken Paxton is one of his heroes. He is a leader of the Republican Party, and he is the Attorney General. This young man is bothered by it enough that he eventually asks him and says, hey, what was the deal with that? And this young man does not get an answer of which satisfies him. The whistleblowers now come forward and disclose their information. It is after that that this young man is offered a promotion. He declines, and he leaves the office. After he leaves the office, he continues to get a stipend and a check from Ken Paxton's campaign for $250 a month. He calls repeatedly, says, I don't want this money, please stop it. It goes on for about 4 months. At the point in time that it finally stops, he writes a check and he sends it back to the campaign without anybody knowing about it. This is the kind of integrity of the people that we describe when we say that the committee investigators have met with more than 15 people, many of them Republicans, many of them who worked in the office as civil servants, and many of them deeply conflicted about the information about what they had to disclose and the individual, because each of them, almost to a fault, attempted to remain loyal and help Ken Paxton. In these two articles, again, Ken Paxton, he broke the law. He received an improper gift to a public servant, a Class A misdemeanor carrying up to a year in a local jail. He again has the appearance of bribery, a second-degree felony. You all get to judge, like that cart coming down the aisle. Are these just individual isolated incidents of which you can dismiss, or are they an unexplainable pattern of ongoing criminal conduct? Articles 12, 13, 14, and 16, these relate to the underlying securities fraud, failure to properly disclose and register. And I think that Speaker Guerin said it best in our hearing if you were watching, because at one point there's a discussion about a $100,000 gift given to Ken Paxton. And the issue was the fact that he originally did not disclose it as a securities operator to say, hey, I have a vested interest in what I'm getting, and it's either an improper donation and disclosure, of which he is aware of the laws and obligations for transparency. And when he gets busted on that, he says, no, it's just a gift. And somebody says, what do you mean it's a gift? And he says, I met a guy in a Dairy Queen, and he told me God told me to give you this $100,000. Speaker Guerin said it really well. I have never had anybody come up to me and said, God told me that I should give you $100,000. That's not the only $100,000 incident. There is another $100,000 gift, which is a donation to his legal defense fund, and there is another questionable securities issue gift with regard to the Maori Corporation. We see, like in those circumstances, that it is his opportunity to delay and extend the court proceedings that keep him from never having to go to court. We bring those incidents to you to look at that whole aisle, to determine the course of conduct that he has set in motion for almost a decade. Is that part of his MO? It is when he gets caught in those circumstances that he will say, oh no, I'm sorry, I forgot, I didn't realize, I should have registered it this other way. There are probably a lot of folks in here that speed. You may have a lead foot. And I now want you to think about how many tickets you've gotten, because you've spent a whole lot more than you've been caught. And these are 3 instances of payments of large amounts of cash to a man that he did not attempt to correct until busted. Articles 6, 7, and 8 deal with the whistleblowers. These individuals who were doing everything they could on behalf of the state of Texas and everything they could on behalf of that office, they were fired. They were not only fired, they were shamed. It stained their reputation and it stained their careers as great public servants and law enforcement officers in an attempt for Ken Paxton to save his own skin. Through this investigation, those individuals have been talked to, but I will tell you there are others. There are those that are not yet brave enough to come forward, and we won't judge them. Because it's almost like, why would you? This guy has gone almost a decade manipulating the processes, throwing false narratives out, and almost proving himself to be untouchable. We see that same MO starting now. Complaints of process, and I haven't gotten to tell my story. This is his story. This document, almost 400 pages, was sitting on his website for years. This is his answer to the whistleblower's complaint. This document went missing after we said, don't do anything with any of the evidence in this case, and you are currently under investigation. I guess it is hard to walk into a committee and claim nobody has asked you any questions or looked at process if this sucker's still sitting on your website. It is gone. And it is illogical that somebody wouldn't have realized that we would have printed out a copy. Not only did we print out a copy, but the committee investigators reviewed this report, and in the hearing, you can start on page 124, line 10, and you can go all the way to 130:19, where the investigators say not only did we review everything and talk to the witnesses involved and looked at the evidence, but page 46, false claim. Page 5, false claim. Again, page 5, false claim. Page 49, false. Page 5, misleading. Page 49, false. Page 50, false. Page 6, false. Pages 5 and 6, false. Page 42, false. Page 52, false. Page 7, misleading. Page 39, false. Page 39, again, false. Page 39, false. Page 39, false. Again, accusation, false. Accusation, false. Accusation, false. Page 34, false. And then asked, do you want me to keep going? Please. False. Page 52, false. Page 56, false. Shockingly or not shockingly, Ken Paxton's office investigation into whether or not Ken Paxton committed his own crimes has been and recognized to be repeatedly false. Again, with regard to the whistleblowers, Ken Paxton, he broke the law. Retaliation under our government code is a felony of the 3rd degree carrying another 2 to 10 years in prison. Official oppression is a Class A misdemeanor warranting a year in a local county jail, and the government code 554.002 of the whistleblower statute and civil penalties. Articles 16, 17, and 18 go to the ideas that this gentleman is no longer fit for service or for office, that what he has done has impugned the integrity of our court system and those who have worked very hard to keep it functioning. We asked a question to the committee investigators about what they found about those whistleblowers and the courage that they demonstrated. Quote, "The thing that I think struck all of us in our investigation, not only in speaking with whistleblowers but other high-ranking officials at the Attorney General's office, is that these are individuals who are extremely well-credentialed and qualified. These are individuals who had taken upon their role as public servants to do their oath. Is what their oath asked them to do, to uphold the laws of the state of Texas and to uphold the Constitution. Many of the people that we spoke with, specifically some of the whistleblowers, are known outside of the office of the Attorney General's circle. They are well-respected former law enforcement. They are well-respected attorneys. They're individuals who are considered subject matter experts in the field, and they are oftentimes the cream of the crop. They rose to the positions that they are in because of their work ethic and because of their dedication. And the feeling was shared almost universally that the actions that they were being asked to take, the positions that they were being put in, and the decisions made by the Attorney General sullied their office and sullied their commitment and their careers. I've had the opportunity to work in criminal courts for almost 20 years, and I feel for you in the same way that I feel for jurors. Nobody asked to have to be brought in to make these judgments. But I will say it is not you who asked to be here, but it is the person who continually broke the law. And that man is Kenneth Paxton. This story now comes to the fork in the road for all of us. And either this is going to be the beginning of the end of his criminal reign, or God help us with the harms that will come to all Texans if he is allowed to stay the top cop on the take. If millions of Texans can't trust us to do the right thing right here, right now, then what are we here for?
The chair recognizes Mr. Murr.
Members, you've heard about the whistleblower lawsuit. You've heard about the work performed by the General Investigating Committee. You've received a summary of the facts and an explanation of the charges outlined in the articles. Mr. Speaker, I believe we're now ready and willing to take any questions that any members have.
Mr. Schaefer, for what purpose?
The gentleman yield for some questions.
The gentleman yield for questions.
Yes.
The gentleman yields.
Thank you, Chairman Murr. In your role as a member of the General Investigations Committee, did you interview any witnesses as part of the investigation of Attorney General Paxton?
As you heard during our explanation, when we learned about the request for multi-million-dollar payment of settlement back in February, the General Investigating Committee undertook the efforts to hire highly qualified, experienced attorneys and investigators to perform those interviews for us and then report that information back to the committee.
Did you interview any witnesses?
As I explained, the folks that we hired to work for the committee did the interviewing.
Did any member of the General Investigations Committee cross-examine a witness?
As I've just explained to you, we hired long, skilled, and qualified attorneys and investigators to do that work for us. And it was conducted in a very professional manner. Each of those investigations and interviews involved the attorneys for the witnesses, including the whistleblowers.
Chairman Murr, are you aware of any member of the Texas House of Representatives who was given an opportunity to interview witnesses?
So I'm going to answer that in a broad stroke because I understand that you're trying to make a point, but what I'll tell you is this originated with the request for $3.3 million, and that started back in February when we understood that a settlement agreement had been reached by parties in that litigation.
I understand.
I understand. I'll finish. At that time, Mr. Paxton and members from his office actually appeared before an appropriations subcommittee and requested payment of funds, but declined to answer questions as to what happened in the lawsuit.
Chairman Murr, do you know whether any witnesses that spoke to the investigators hired by the committee were placed under oath?
No witnesses were placed under oath, analogous to any investigation that you would have into criminal activity. Typically, you do not see law enforcement or investigators place a victim or a witness under oath. That occurrence occurs at a trial. And as you're well aware, and we just issued a memo explaining the process of impeachment, this is not the body that does the fact-finding. The fact-finding occurs in the Senate, and the oath for any witness would occur there.
Well, Chairman Murr, you said when you came up to the dais that you've heard the facts, and I would agree, we have not heard facts yet because no facts have been established. Are you aware of any transcripts or video recordings of witness interviews conducted under the auspices of the General Investigations Committee?
Yes.
Were those witness interviews, transcripts, or video recordings ever made available to the full membership of the Texas House of Representatives?
Importantly, the transcript from the multi-hour presentation by our retained attorneys and investigators was made available on our committee website and published and printed for all the members of this body.
Were there transcripts of the investigators interviewing witnesses?
Recordings were made of each interview.
Were those recordings made available to the membership of this body?
No, those are part of the investigatory process of the General Investigating Committee.
Chairman Murr, have the members of the full House been given the opportunity to ask questions to the persons hired by the General Investigations Committee to investigate Ken Paxton?
Those questions were made by members of the committee, and I'll point out that our House rules for almost a decade have embodied the role of the General Investigating Committee to be the workhorse on investigation on behalf of the body, both in areas of concern around the state as set forth in the government code and specifically with respect to articles of impeachment.
Chairman Murr, will any member of the Texas House as part of this proceeding be able to ask questions to the persons who investigated Ken Paxton?
Right now, today, you have the report from the committee before you, and we have done that work on behalf of the committee, pursuant to the House rules, pursuant to the government code, and so we are providing that information to you.
As part of this proceeding today, will the members of this body be presented with any witness transcripts?
We have provided a transcript of the multi-hour hearing. The video is also available to you.
Were there any witnesses that testified in that hearing you're referring to?
No, that was a hearing in which the attorneys and the investigators that were hired by the General Investigating Committee provided a detailed and fact-specific summary of all the evidence from their 15 interviews of witnesses and the culmination of reading pleadings and documents and other information that they gathered.
Chairman Murr, has any member of this body heard directly from a witness that was involved in this investigation?
I'm not advised of that because there's no restriction for any member here to reach out to any participant in the whistleblower allegations and the lawsuit. It's been going on literally for more than 2 years, so I'm not advised.
Have you made any opportunity through the auspices of your committee for the witnesses to engage with the members?
That is the purpose of the committee, but if members wanted to engage directly with that, I don't think there's any restriction, but I'm not advised if that has occurred.
So there were no restrictions, but your committee chose not to make an opportunity for the members to talk to witnesses. Is that correct?
Again, I will point out that the construction of the House rules for almost a decade, as well as the government code, establish investigating authority with the General Investigating Committee. And so that is the workhorse for your investigation purposes.
But is it not correct to say that your committee could have made witnesses available for the membership to speak with and ask questions?
So I will point out, whenever you bring that up, that let's start first with the whistleblower lawsuit. Whistleblower lawsuit involved 4 individuals who were terminated from their employment because they feel like they did the right thing. They identified what they realized was criminal wrongdoing. They went to law enforcement and reported it. They reported that to HR to some extent, but were terminated, were fired from their jobs. Now, other people that learned about that, they went ahead and resigned because they said, I can't work in that environment. All said, we learned, and you're aware, that of 15 witness interviews, all but one said that they had grave concerns for retaliation from Mr. Paxton on a professional basis, that it might affect their livelihoods, their ability to keep or get a job, similar with their spouses. So they were very concerned about that. This work, and I'll finish, this work was done with the fact that some of those folks that agreed to sit down or were subpoenaed and sat down and did interviews did so while they said, I will certainly appear at a trial and under oath provide testimony. I am concerned about my name being out there. I am concerned about unnecessary exposure when I'm living in a world of a little fear and retaliation every day.
Chairman Murray, you and I heard the presentation by Representative Johnson. And in that presentation, she said that all roads lead to Nate Paul. Do you remember her saying that?
I heard that.
Did the committee compel any testimony from Nate Paul?
The committee began its work by reaching out to the participants in the whistleblower lawsuit, and from there went to witnesses identified by those folks. So those would be participants who were not in the whistleblower lawsuit. The committee has not reached out to Mr. Paul.
Did the committee subpoena any documents from Nate Paul?
The committee has not yet subpoenaed any documents from Nate Paul.
Thank you, Mr. Chairman.
Mr. Tyndall, for what purpose?
Thank you, Mr. Speaker. Will the gentleman yield for questions?
The gentleman yield for questions.
I yield.
Thank you, Chairman. How many investigators were there?
Hired a total of 2 investigators, and that was laid out, I think you heard that from Chairman Longoria as he presented.
And so essentially, but there were 5 people that were hired. Was it 5 or 6 that were hired?
6.
Okay. So I misunderstood. I thought there was 5. So how were they chosen?
The active goal was to look for folks that had experience, especially in public integrity matters, white-collar crime, and preferred to have experience gathering information and with a keen eye of whether or not any criminal conduct occurred, because that was the basis of the allegations in the whistleblower lawsuit.
So we're all, I will accidentally say 5 because that's what I have written in here, but were they all from the same city or county?
No.
Had they all worked in Harris County in the past?
To my knowledge, off and on, they may have, but not all of them at the same time.
Would you be surprised if I told you that of the 5 that I was aware of, all 5 of them worked in Harris County with the vice chair of the committee that you're the chair of that initiated this resolution? Would you be surprised by that?
I also wouldn't be surprised, as you have Chairman Dutton behind you, that Harris County has over 2 million people and a lot more attorneys and investigators than many other jurisdictions around the state of Texas.
Would you be surprised to find out that 3 of those 5 were fired by their district attorney at one point?
I believe that you will also learn that they have experience that spans decades and oftentimes worked in environments that swayed and ebbed and flowed pursuant to elected officials.
Are you aware that 3 of the attorneys vote in Democrat primaries, and one of them switched to be a Democrat in primaries in 2020?
I do not care how they voted in a primary or an election in Harris County. What I do care about is their work product, their ability to conduct themselves professionally, and to provide an opportunity to gather detailed information on behalf of the General Investigating Committee.
Do you see how it could appear or it could be perceived by anyone in the building or outside the building when they're Democrats? Could you see how it could appear that it's politically motivated investigation?
No,
on their behalf.
I could also see that multiple of those persons that we hired to work for us also worked in the U.S. Attorney's Office for a Republican appointee from a Republican president. So, no, I do not see that appearance.
I believe perception is truth to the person that perceives. So if someone perceives something, it's truth to them, whether it's truth or not. And so I think the hiring and where they're from and the fact that they were fired and that they're Democrats could create the perception that this was politically motivated.
I disagree completely with you.
So my understanding is that they did not reach out to anyone in Attorney General Ken Paxton's office, not from the highest levels or the lowest levels during their investigation. Is that correct?
So as I explained earlier, and you've heard other explanations, in February, Mr. Paxton and members of his staff appeared before the Appropriations Subcommittee and requested $3.3 million to fund a settlement, but declined to provide any additional information. Now, I do know, and we've heard explanation, that a almost 400-page document was produced on their website in defense of that lawsuit, and that's where things were.
So, so none of them were talked to since March when this investigation was initiated?
No, sir. We began with the whistleblowers to learn more information about the claims that they had made in their lawsuit.
So we've had a couple of impeachment proceedings over the history of Texas, and in both of those, the opposing party was talked to. As a matter of fact, let's just talk 1975. In 1975, they had 70 to 90 hours of open testimony and meetings. You had 1 day. And those hours that were given, anyone could go watch them and listen to them, and both sides were afforded the opportunity to say their side. In the 1917 case, I believe, they were on the floor in a committee of the whole, and the chairman was asked questions by committee members. The reason I'm saying all this is there's no testimony. As a matter of fact, the AG's office tried to go to your committee on the 24th and were not allowed. That's concerning for me. Can you explain why Attorney General Paxton's office was not contacted, not allowed to testify on their own behalf?
You've got a lot in your questions, so if you'll give me a little
Yes.
latitude here to try to address several different topics. So you talk about 1917, you talk about 1975. In 1917, it involved a recently resigned governor who's no longer in office. In 1975, it involved a district judge from a single county in the state of Texas. Those both involved an era in which didn't contain current House rules that were designed to put the power of adopting articles of impeachment into a committee such as General Investigating. So therefore, you saw, as you mentioned, a committee of the whole, and I explained that in a memorandum that we provided to this body yesterday. Comparatively to a recently resigned governor or a district judge in a single county in the state of Texas, we are talking about an accused person that is currently in the highest elected office for an attorney in the state of Texas. He sits in that office and can use the significant powers granted to the Attorney General to do a lot of different things. And that makes it very concerning whenever you're going through this process, as you've seen in the last few days. We have seen literally the Attorney General use his agency to lobby this legislature. We have seen the Attorney General call people on the floor.
When you say that,
lobby.
you're making accusations. I hadn't heard that. I'm not saying it's not true, but you're levying that like that is actual truth. Did he call your office?
No, he did not call my office,
Okay.
but I'm familiar with the fact that there are members on this floor that have received telephone calls from the Attorney General.
So are you aware
just
that,
the last few days.
Are you aware that in 1975, they didn't give us 48 hours to decide, They gave us both sides of the story, and they gave 3 weeks to decide. Why are we given 48 hours to make this decision and be here today? I feel like it's rushed. I perceive that it could be political weaponization. And I'm asking, why are we given 48 hours when in 1975 they were given 3 weeks with both sides of the story?
You know, if you'll look at the investigatory process in 1975, it lasted approximately 50, 60 days. And so I appreciate the fact that for you it seems sudden and rushed, but for the purposes of the committee, we have been working on this since February, whenever this legislature was asked to spend taxpayer dollars to fund the settlement of a whistleblower lawsuit.
Why didn't we know about that till now?
And this committee's been working since March, and the culmination of our work was placed and downloaded into a very long and lengthy, detailed public meeting, which the video is publicly available and the transcript is publicly available.
So why weren't we, as members, not apprised of what was being investigated for 2 months when historically the members know? The public knows.
As you are well aware, the House rules, committee rules, and actually sections of the government code place the authority to do investigation with the General Investigating Committee. And in some instances, as you're well aware, that is done in the confidence both to protect those that raise concerns, protect the process for as witnesses go, and to protect the end result, which is providing evidence and information.
So let's compare two investigations without names. There was matter A and B. In the matter that we disposed of earlier this month, the opposing party, the party that was being blamed for something, was asked to testify, as were the people in and around this individual's office. So both sides came and testified to you, or were given the opportunity. Can you tell us why in this case they weren't allowed to, but in the other case that was disposed of this same month, the other case they were allowed to and asked to?
I understand, and respectfully, you're comparing an apple and an orange. So when you talk about matter B, talk about a process that involved written complaints of workplace misconduct. That is addressed in the housekeeping resolution, in the House rules, and the committee rules. And it's handled in a very special and specific way. And that is not necessarily the same framework in which we're talking about the articles that we have before us today, which involve also committee functions, but they can be derived in the government code as well as our House rules, but in different sections.
So I believe that they're both also similar in the fact that we removed a duly elected state official from their seat, and this is potentially what's going to happen to this individual. So I see large similarities. A couple of other small questions that I want to close out with is, are you aware that both Trump and Cruz made statements about this today? Are you aware that they both did?
I'm not advised.
Okay, they both did, and I'll spare the body some of the statements that Trump made because I don't want to engage in personalities. But Ted Cruz, are you aware that he's a constitutional attorney?
I'm not advised.
He is, and he basically talks about the swamp once this individual moved out of their office, and he's showing full support for the Attorney General. I'm just wondering if you have any statement about that when he's actually seen recently one of the most egregious impeachments in the history of the United States, and he's speaking about it. Do you have any statement about that?
I would only direct he and members of the public to go and watch the video of our investigators and attorneys providing detailed information to the committee and/or read the transcript that's publicly available.
So my last question is, how much did these investigations cost us? Because we were never made aware. We weren't asked about it. Just can you give us an estimation of what was spent to conduct these investigations?
I am not advised of that.
Okay, thank you for being respectful, and I appreciate you, sir.
The time for proponents' open statements has closed. Chair recognizes Mr. Smithy. We will now hear opening statements from the opponents of the resolution.
Mr. Speaker, parliamentary inquiry.
Please state your inquiry.
It was laid out that the opening remarks were only going to be 30 minutes. They went significantly longer than that. Are we not going to have the opportunity in turn for more questions.
The chair stated that the opening statements would not impact the time allowed for questions, and they did not. The full 20 minutes was allowed for questions.
There's no extension.
And the hour taken in opening testimony will count against them in general debate. Mr. Dutton, for what purpose?
I'd like to ask the representative questions.
Mr. Smithy, or
Mr. Smithy.
not at this time? Mr. Smithy is going to begin his opening remarks.
Okay.
Under the previously adopted resolution, Mr. Smithy has 30 minutes of uninterrupted remarks. Chair recognizes Mr. Smithy.
Thank you, Mr. Speaker and members. And I assure you, I'm not going to take 30 minutes. But let me tell you, first of all, I'm not here today to tell you that General Paxton should not be impeached. That's not why I'm here. Bottom line is, I don't know whether he should or not because I don't have the evidence before me to make that determination. All I'm telling you is this House cannot legitimately and in good faith and under the rule of law impeach General Paxton today on the record that it has before it. I'm not here to defend Ken Paxton. That's not my job. I'll leave that to someone else. But I'm here to defend two things that are precious to me. One is the rule of law, and the other is the integrity of the Texas House of Representatives, of which I've given a good part, the best part of my adult life. What we're doing here today is very important. You've heard that. It's a very sober and somber experience and process, and it should be. And there's three reasons for that. You've heard, and I've heard conversation on the floor from members, and we've heard a bit of this today. This is only like a grand jury. We don't need to adjudicate guilt or innocence, and that's true. But this House, historically, and with its president, has always applied a higher standard to these proceedings than it has to a typical grand jury. The House has always been concerned about due process and constitutional rights, and above all, the fairness that goes with a process such as this. And there are three reasons for that. Three very, in my opinion, very compelling reasons. The first is that our actions today have an immediate consequence. If we vote to impeach today, as soon as we do that, then General Paxton will be automatically relieved of his duties. He will no longer function as Attorney General of the state of Texas. It's what I call the hang 'em now and judge 'em later policy. The consequences of our impeachment is that he will be removed from the responsibilities of his office, even though his guilt or innocence has not yet been adjudicated. The second reason that the House has always insisted on a complete record, which we have no record before us, no record, no report before us. But the second reason is it is our responsibility to provide a record upon which the Senate can make its adjudication of guilt or innocence. Yes, they will have a trial there, but the basis for that trial is the record that we prepare here in the House, and there is no record to send to the Senate. The third reason, and to me this is extremely important, and that is just as we should be but are not looking at precedents of the Texas House, future legislatures should and probably will be looking at this precedent. We do not need to be relaxing the due process and the fairness concerns. When we go home, these are important. When we go home, we'll have to defend, each one of us as members will have to defend not only the final result that we reach today and the way we vote, but we'll also have to defend the process by which this determination was made. And members of the House, to me, this process is indefensible. It's absolutely indefensible. Not to be critical of anyone, but when you look at the precedent precedent is so important. I recently argued a case in the Supreme Court of Texas, and our argument was that precedent matters. And as the court pointed out in both its majority and concurring opinions, it said that precedent is important for two reasons. One is because of predictability and the other is stability. Stability and predictability. That's important in the law, and it's important in House and Senate procedure. Now, as we approach this today, we basically have two prior impeachment proceedings and one that began as an impeachment proceeding, actually two that began, that are instructive for us. The first one has been mentioned. It's the 1917 impeachment of Governor Ferguson. And in that, there are several things that are very instructive historically that occurred in that particular impeachment. First, the House has always adopted rules in advance of, and they have always authorized the investigation into the public official. That way it is done out in public. It is done with the antiseptic of sunlight. This was not done that way, but rules are adopted in advance. We received the small rules that we have less than a few hours ago. The rules were made up as we went in this process, and that's not the way it should be. One of the things that the rules have always required, since 1917, again in 1929 in the aborted Robinson Land Commissioner impeachment, and again in 1975 in the Carrillo impeachment, one thing that the legislature has always insisted on is that the proceedings be done in public, that the public have access, the public have knowledge. Now, I think it's ironic that we're conducting this hearing today, we're doing this determination today during a holiday weekend when most of our constituents are busy doing what you should be doing on Memorial Day weekend, and that's memorializing those who've given all for this country, or else they're spending time with their family. They're not concerned about this. It's like dumping information late on a Friday afternoon of a news cycle. We should be doing this in the open daylight. We should be doing it not with 48 hours notice. We actually had less than 24 hours notice that we were going to do this today. We should be doing this with full notice and full opportunity for the public to participate, not directly in the House chamber, but to watch and to attend if they choose to do that. And we shouldn't do it on a holiday weekend. We've always had the public involved throughout the process, in the hearings, the committee hearings, and all throughout the process. Another thing that they did in 1917 that they've done continuously since then, they have always said that the accused, in this case General Paxton, had the right to be represented by counsel during the proceedings. There is no indication in the record that General Paxton was ever afforded that opportunity. Number three, since 1917 and all of the intervening impeachment proceedings since then, counsel for the accused has been permitted the opportunity to cross-examine the witnesses. And that never occurred because no witnesses were ever examined in this case. Not one witness was ever examined by the committee. Not one fact witness who knew anything about anything was examined in the committee. Do you know how it worked? They had these investigators, these kind of anonymous investigators. We know their names. We know a little bit about them. These investigators, they came and spoke to the committee. From the record that I've been able to uncover, and I confirmed this with Mr. Murr, they were not even required to sign witness affirmation statements before the committee. Now, we require witness affirmation statements when somebody testifies on behalf of a local or an uncontested bill, but we didn't require it in this instance. And what you've heard and what's in this report is not one shred of evidence. You're all familiar with the term hearsay, but what you have in this case is triple hearsay in most cases. It is hearsay within hearsay within hearsay. No prosecutor would ever try to get a grand jury indictment based solely on hearsay within hearsay within hearsay. No jury would ever convict. No civil jury could ever award judgment or enter a verdict based on the evidence that's before this House today. And so that's another thing. There was no ability for counsel for Mr. Paxton to cross-examine. There was no opportunity for anyone to cross-examine. In 1917, the House determined that the impeachment proceeding would be conducted as a trial with all of the due process requirements in place normally given. Now, that's not the case with grand jury proceedings. But the House was convinced that it wanted to go the extra mile in providing fairness and notice. And so it was conducted as a trial. And one other thing that applies to every impeachment that has ever been done in the Texas House of Representatives has been that all evidence must meet the standard required under the Texas Rules of Evidence. And I will tell you, there is not one word, not one sentence in the testimony before you that would be admissible in any Texas court of law under the Texas Rules of Evidence. It is hearsay, within hearsay, within hearsay. Here's something else that is troubling. In a court of law, some of you have testified. You are sworn under oath. You testify under oath that on your honor that you will tell the whole truth and nothing but the truth, so help your God, okay? And if you don't do that, and it is later found out, you are subject to charges for perjury. And because of that limitation, most people, not all people, but most people tell the truth when they're giving official testimony. It concerns me, and I hope it concerns you, that in this case, in this impeachment proceeding, not one witness was put under oath. Not the investigators who testified what person A testified that person B told them. Person A was never put under oath. Person B was never put under oath. No one was put under oath. And so you have all these things that amount to accusations, but not testimony and certainly not evidence. And that concerns me. It concerns me a lot because today it could be General Paxton, tomorrow it could be you, and the next day it could be me. Our fundamental rights of due process are so important to every one of us, and they're important to preserving the republic that we have. Now, one other thing, as I said, the testimony has always, in the Texas House, any testimony used to convict someone, to impeach someone, has always been under oath with penalty of perjury. And another thing that has always been done, and we're breaking precedent in that regard, is counsel for the accused has always been permitted to attend within the House chamber, the open chamber of the House, to represent the accused. Members of the House have always been given the opportunity, even though they will not serve on the committee, they have been given the opportunity to submit written questions to be asked of the witnesses. That never, ever occurred in this case. So in 1917, you had rules adopted in advance, so everybody knew what the rules were. You had the public involved in the proceedings. You had the accused with the right to be represented by counsel. You had the right to cross-examination. It was conducted like a trial. Evidence was admissible, and all testimony was given under oath. That was what due process and fairness looked like in the Texas House of Representatives in 1917. And in my opinion, that's what due process and fairness should still look like today, not only in the Texas House of Representatives, but everywhere. Let's talk a minute about the 1975 impeachment of proceeding involving Judge O.P. Carrillo. Two members of our House were present for that. Speaker Craddock and Representative Thompson were both present for that. The author, many of you know, was Terry Canales Sr., who was, and I believe Mr. Bryant was present at that time too. But Terry Canales Sr. was the author of the impeachment resolution. But it's very instructive what happened in 1975, because at the beginning of the proceeding, Judge Carrillo was notified that there was an impeachment proceeding investigation pending. And the House Select Committee sent this notice directly to Judge Carrillo by telegram. They said, you are invited to be present in person or by an attorney. Any evidence you care to present bearing on the inquiry will be welcome. The principal function of this committee is to develop facts, and your assistance in this endeavor will be appreciated. And so the accused was told, if you've got any evidence, anything you want us to know, anything you want us that might that might be used to exculpate your guilt in this case, we want to see it because we want to be fair and we want due process. And so that's what fairness, that's what due process looked like in the Texas House in 1975, and that's the way it should still look. We've learned from the record and from talking to some of the committee members that General Paxton was never notified of these proceedings. He was never invited, much less allowed, to provide any material, any evidence, or any testimony that might in any way be exculpatory toward his guilt. That is not fairness. That is not due process. That is not the way that things should be done. A couple of other words about the Carrillo impeachment proceeding. Their members then were allowed to submit questions. All members were involved, were allowed to submit questions to all of the witnesses. They actually had witnesses in that case. There were 32 witnesses, as a matter of fact. All witnesses who testified were testifying based on personal knowledge, not one in this case based on personal knowledge. And they testified under oath for approximately 70 hours of testimony before the House committee that considered impeachment in that situation. They accumulated 15 volumes of testimony. They had 170 documents in evidence. What we have is we don't have a report. We've always had a report. There's no report. There is a transcript, and it is 170 pages, somewhere in that range. It's thin. It's just 170 pages. Not one document. In that case, 170 documents were submitted as part of the report in evidence. In this case, although multiple documents are referred to as being highly incriminatory to General Paxton, are referred to in the report, not one of those documents has been provided to the House, and not one is attached to any report that's been provided to the House. And so you have that matter of due process. It's like in 1975, the House embarked on a slow and deliberative process. They invited the accused to attend and present any evidence that might bear on his innocence. And they gave the opportunity for cross-examination by the counsel for the accused. And that was what due process and fairness looked like in 1975 in the Texas House, and is what it should look like here today. You know, members, I'm aware that there are certain members in this House, certain people in this chamber, who want to get rid of General Paxton for whatever reason in the worst possible way. And I'm here to tell you that what we are doing is absolutely the worst possible way. There's a right way to do things, and there's a wrong way to do things. If you want to do this the right way, what we should do is vote no on the resolution today. If you want to, we can come back as a committee and do this the right way. And the right way would be to ask we have subpoena power. We can compel these witnesses who supposedly have factual knowledge, we can compel them to come in, testify under oath with opportunity for cross-examination. We can notify the Attorney General. We can subpoena documents. We can allow the Attorney General to appear and present any exculpatory material that he might have, and we can do it the right way. And the committee can do that after we have adjourned the session. We can be called back for a one-day hearing to consider a real record that gives us a sufficient basis. You've heard this compared to a grand jury proceeding, and in some ways it's like a grand jury proceeding, and in other ways it is not. But I can tell you this, that no grand jury can legitimately indict any individual, any potential criminal defendant without evidence. You can't indict without evidence, period. And what you're being asked to do today is to impeach without evidence. It is all rumor, it is all innuendo, it is all speculation. It is all things that we may speculate to be true, but we don't have what is defined or what qualifies as evidence in any court at law, not only in Texas, not only in the United States, but in most developed countries in the world. And so I would just say this, that if I'm ever going to be in part of any impeachment proceeding that actually results in the impeachment of an officer, I don't want it to look like a Saturday mob out for an afternoon lynching. I want it to look like a clear, deliberative, somber, and sober exercise in the quasi-judicial function that the Constitution gives us the right to engage in. Members, thank you so much for your attention today. I appreciate the time you've given me.
The chair recognizes Mr. Tinderholt. The chair advises our guests under the rules of the House, demonstrations or outbursts by visitors in the gallery are strictly prohibited. The chair recognizes Mr. Tinderholt.
Thank you, Mr. Speaker. Members, it's a sad day for our chamber. We often talk in this building about transparency in everything that we do because our voters deserve that. I feel like there wasn't a lot of transparency for the entire 2 months of this. The Texas House is taking a practice that's only been used twice in Texas history and deviating severely from that practice instead of carefully deliberating on this issue as those who came before us. We've decided our chamber is nothing more than a weapon to wield against political opponents. This body is afforded more time for debating tampon tax relief than we've given to deciding whether to impeach the highest law enforcement officer in our state. Let me tell you, I don't think today is about whether there's guilt or innocence. It's about the process. At the beginning of this session, Speaker Phelan ruled this chamber wasn't allowed to debate legislation or rules that could be seen as using it for political purposes. This is political purposes. Now our Attorney General, who was strongly reelected by the voters in both our primary and general election, might be impeached today because he's a political opponent of the opposing party. Members, I'm deeply concerned by the way this investigation is handled. The current House is totally breaking with precedent for considering an impeachment according to the last 2 ones we've done in history. The General Investigating Committee never interviewed the Attorney General, never interviewed top staff, or anybody else, especially when they showed up on the 24th. Why? I can't answer that question, but I can say that it creates horrible perception. According to Chairman Murr, this matter has been under investigation for approximately 2 months, and records show that to be true. But our chamber was never informed as to what was being investigated. Does pushing this through so quickly in the late hours of session seem ethical, thoughtful, or responsible? I say no. I've heard many of you say in the past you don't want Austin to look like D.C. The sad reality is that Adam Schiff and Nancy Pelosi put more time and deliberation into the impeachment of Donald Trump than the Texas House has done in the last week regarding this matter. For my Republican colleagues, I want to let you know that I'm sorry that you're being used like this. I'm sorry you're being forced to swallow a long list of policy that was killed this chamber and then be used to impeach one of the most popular Republicans in our state. Remember, we're not talking about whether there's guilt or innocence. We're talking about process. The same voters that sent each of us here elected him as our Attorney General. Some don't like that. But to make a last-minute decision to impeach him without due process or transparency is imprudent at best and a gross abuse of power at worst. This session, the General Investigating Committee has investigated 2 matters that we know of. In one, the respondent was afforded due process to respond to the allegations while the committee was convened in an executive session. On May 24th, Chris Hilton, the chief of general litigation at the OAG, made an appearance at the General Investigating Committee and attempted to register as a resource witness in defense of Paxton. He was denied by the committee. According to the OAG, the General Litigation Division has a broad practice that includes defending state agencies, elected and appointed officials, and state officials and employees in civil litigation. That's their job. They showed up to do it, and they weren't afforded the opportunity. This is one-sided. In 1975, it was the last time the legislature initiated impeachment proceedings against any official. After a single member filed a resolution recommending impeachment, a select committee on impeachment was appointed to investigate. Across almost 2 months, 21 committee meetings, and 90 hours of consideration, the committee interviewed 32 witnesses with direct insight totaling 70 hours of public testimony. The findings of the committee, as well as the transcripts of public testimony, were combined into 16 volumes and distributed to members 3 weeks prior to floor consideration of articles of impeachment, and we have 48. In our case, well, think about that for a moment. We have 48 hours after everything was secret except one meeting. In our case, the General Investigating Committee called their own investigators as witnesses in the single public hearing regarding impeachment. Instead of questioning the witnesses in public hearing, the committee allowed the investigators to summarize and potentially editorialize their findings. Is this really what we've come to? If you think this is how we best serve Texans, you're gravely mistaken. When you vote today, don't listen to bullies inside or outside this building that try to intimidate you into submission. You're better than that. I know you all. This is wrong. You know it. Your voters know it. When you go home, don't end our session this way. Don't tarnish this institution. Don't cheapen the act of impeachment. Don't undermine the will of the voters. Don't give Democrats another victory handed to them on a silver platter. There's a better way. And today, that better way includes voting no to these impeachment articles. Thank you.
The chair recognizes Mr. Harrison.
Thank you, Mr. Speaker, members. I rise today in opposition to this resolution with a heavy heart, not just because of the seriousness of the allegations, and they are serious, but because the process, if it can be called that, which led us here. The allegations against Attorney General Paxton are extraordinarily concerning. However, I am equally, if not more, concerned with ensuring that the Texas House is not using the levers of power to criminalize opposition. Whether that is the true intent of today's proceedings or not, it will be forever impossible to divorce what may be virtuous motives from what we are witnessing today, which bears all of the hallmarks of the weaponization of government power to target a political opponent. Now, let me be clear. Texans should demand the highest standards of ethical behavior, propriety, and adherence to just laws from those in high office. It is very possible that standard has not been met by the current Attorney General. He may well have committed acts that are preclusive of being the state's top law enforcement officer. For example, what is not in dispute is that 8 of his most senior officials left amid troubling circumstances, and that he, for whatever reason, chose to cut a settlement with them that did, in fact, expose my constituents and yours to paying millions of dollars. This is, of course, a matter that, as fiduciaries of tax dollars, we should take seriously. In fact, and as an aside, I wish this body demonstrated the same level of concern for every single line item in this budget that was $3 million or more. If a public official is going to come under criminal scrutiny or have allegations raised against them that rise to the level of impeachment, the impeachment proceedings themselves must be unimpeachable. That has not happened here. When the stakes are this high, optics matter, perception matters, process matters. Less than 48 hours ago, and with no warning, we had a resolution containing 20 articles of impeachment quite literally dropped on our desks, along with nothing more than the transcript of one single public hearing. Most of these allegations have been litigated in the criminal justice system for many years, and yet not a shred of anything closely approximating new and sufficient evidence has been presented to this body. At most, the investigation has lasted 8 weeks, and it was kept secret. There was no impeachment committee impaneled, no testimony under oath, no sworn declarations, and when the body was told of this literally hours ago, not one single question directed to the Speaker was met with an answer that inspires any confidence in this process whatsoever. We were given woefully insufficient time to consider all 20 allegations before being asked to take a vote that, if passes, would immediately suspend from office a very recently re-elected Attorney General who has, without a doubt, proven time and time again that he was, in fact, up to the most important task of our time, and that is fighting against the out-of-control federal government which seeks to destroy our rights, our freedoms, our liberties, our state sovereignty, and our Constitution on a daily basis. The questions before us today, colleagues, should be left before the courts and the voters. Finally, impeachments are not primarily about the guilt or innocence of the accused, but rather about protecting the integrity of the state and of our cherished institutions. Those are the things that will outlive